Section 5C offers of securities claims. Section 5C prohibits offering a security without a registration statement. The parties disagree about what test I should apply to determine whether Hart's alleged offer of Hart's crypto assets without a registration statement was domestic. Hart argues that the relevant consideration is the location of the offerer. The SEC claims that it is what the offerers heard while in the United States that should control, and because Hart engaged in conduct, albeit abroad, that targeted U.S. investors, there is insufficient domestic conduct to apply U.S. securities laws. Courts in the district have determined that for an offer to be domestic under the Securities Act, a person or entity must attempt or offer in the United States to dispose of securities or solicit in the United States and offer to buy securities, neither of which we know happen here. She says, here the complaint does not allege that Hart attempted to offer securities during the relevant offer periods while in the United States. Accordingly, I find that the SEC has failed to show that Hart made domestic offers of Hart's crypto assets. Part C, Pulse Chain Fraud Claims. The SEC asserts its Pulse Chain Fraud claims under Section 10B of the Exchange Act, blah, blah, blah. The parties dispute which test governs these claims. The SEC argues that Congress, through Dodd-Frank Wall Street Reform and Consumer Protection Act, conducts and effects, test for SEC anti-fraud actions. Hart argues that Morrison's, we talked about Morrison and Binance earlier, Hart argues that Morrison's transactional tests govern because Dodd-Frank's plain language does not rebut the presumption against extraterritoriality. Say that 10 times fast. And also because the Second Circuit explicitly questioned of the impact of Dodd-Frank on Morrison. I need not determine which test should govern because the SEC has failed to state a claim for its Pulse Chain Fraud claims under either inquiry. Under Morrison, the SEC again fails to sufficiently allege that participants in the Pulse Chain offering became irrevocably bound in the United States. As discussed above, allegations that crypto assets were deposited into digital wallets on the blockchain by an unknown number of U.S. investors is insufficient. To satisfy the conduct and effects test, the SEC must show, 1, conduct within the United States that constitutes significant steps in furtherance of the violation, or 2, conduct occurring outside the United States that has a foreseeable substantial effect within the United States. Here, the SEC fails to allege sufficient facts that place Hart's conduct within the United States. For example, the SEC alleged that Hart discussed the benefits of Pulse Chain, its profit potential, and its development efforts on Pulse Chain's website and YouTube. Notably, the complaint fails to allege that this conduct was directed at the United States. Instead, it merely alleges this conduct originated abroad through online activities. As such, I cannot reasonably infer that Hart's conduct was conducted within the United States. Been saying that all along. The SEC also fails to satisfy the effects test. The complaint alleges that some investors in the U.S. deposited crypto assets during the Pulse Chain offer period. This fails to show the alleged fraud had a substantial effect in the United States. The court has no information regarding the percentage of the defendant's shares that were owned by United States investors, and therefore cannot find that the fraud would have had a substantial effect in the United States or upon U.S. citizens. Let's go down here. For the reasons discussed above, I find the SEC has failed to state a claim for its Pulse Chain fraud claims. Oh, last part, boys and girls. Leave to amend, part 3. The SEC asked that I should grant Hart's motion. I grant the SEC leave to amend the complaint. Okay, so if we lose, can we make up another bullshit piece of paper and put it in your desk? The court should freely give leave to amend when justice so requires. This is a liberal and permissive standard that is consistent with our strong preference for resolving disputes on the merits. If the SEC believes in good faith that it can amend the complaint to remedy the deficiencies identified herein, there's a lot of deficiencies, boys. Any such amended complaint must be filed within 20 days of the date of this order. Conclusion. For the reasons set forth, Hart's motion to dismiss is granted. So order dated February 28th, 2025, Brooklyn, New York, Judge Carol Bagley Amon. Well said, Judge Carol. That was amazing. I mean, look, I don't. So they have 20 days to amend it. I think there's probably a snowball's chance in hell of that even happening. I don't think that they'll attempt to. We've got new Gensler's off, working for another crony somewhere probably by now. I don't think we're going to see that happen. But again, the Nuclear Herbs pointed this out earlier. There is a small chance, they could do that. The door is open because they asked for it to be, and I, would expect that they'd be allowed to do that. But she decimated everything they said. They lost on all counts. I mean, this was like if you guys played Little League Baseball. I did, and we were generally pretty good, but we got 10-run ruled a couple times. Yeah, that's where they stopped the game in like the fourth inning because you're getting your ass kicked. Well, the SEC is that Little League team.